Good afternoon, ladies and gentlemen. These are the public proceedings in the inquiry concerning former Judge Stephen C. Bailey. I am Nancy Nishimura, Chairperson of the Commission. All Commission members are present. Any member of the Commission may ask questions or otherwise participate during these proceedings. Respondent Judge Stephen C. Bailey, formerly of the El Dorado County Superior Court, is present with his counsel, James A. Murphy and Janet L. Everson of San Francisco. The examiners for the Commission are Trial Counsel Mark A. Lizarraga and Assistant Trial Counsels Sei Shimoguchi and Bradford Batson. This is the time and place duly noticed for oral argument pursuant to Commission Rule 132. Once the argument is concluded and the matter is submitted, the Commission will meet in closed session to deliberate. The Commission's decision will be in writing, and it will be served on the parties and will be made public. Pursuant to Rule 136 of the Commission rules, our decision will become final 30 days after it is issued. The respondent has the right to petition the California Supreme Court for review of the Commission's determination. For the benefit of counsel for both sides and Judge Bailey, the members of the Commission have received the transcript of the evidentiary hearing before the Special Masters, as well as the report of the Special Masters and the parties' briefs. In making your arguments, please assume that each commissioner is familiar with the record and the issues presented by the briefs. We have scheduled 1 hour for oral argument. Each side is allotted 30 minutes. Judge Bailey is welcome to address the Commission as part of his 30-minute presentation. The examiner will be heard first. Mr. Lizarraga, you may proceed. Also, please advise if you would like to reserve any time out of your 30 minutes for rebuttal.
Good afternoon. Once again, my name is Mark Lizarraga. I am the examiner in this case. Madam Chairperson, I would like to reserve 10 minutes. May I proceed?
Yes.
That's what I figured.
The examiners in this case requested several additional fact findings and canon violations. Our requests are essentially uncontested, with the exception of Count B, Count 2B, Count 2C, and Count 4B. So with regards to our request for additional fact findings and canon violations, since they're essentially uncontested, I'm going to just submit it on the briefs, unless you all have questions for me, of course. The examiners also made several objections to the master's findings. I cannot go into every single one of those objections. I would like to highlight a few things with regards to Count 3, Count 9, and the aggravating factor, but I would first like to begin with discipline. So it is clear the examiners are requesting that Judge Bailey be censured and barred. As this commission knows, it has identified several factors that are relevant to determining an appropriate sanction. The extent of the misconduct, prior discipline, demonstrate appreciation of misconduct, likelihood of future misconduct, impact of misconduct on judicial system. Now again, I'm allotted 30 minutes. I can't go into every single one of those, but I would like to highlight a few of those, and I would like to start out with the factor of appreciation. If you look at Judge Bailey's responses to the commission, his answer, his briefs to the masters, he clearly has failed to recognize the improprieties acts. He has offered two defense theories. One of them, or the initial one, was that essentially the commission members or the commission is out to get him. He has indicated that the case is politically motivated, and he hasn't just said this in private. He said it publicly. And his accusation is equivalent to saying that the charges lack no merit. And the body bringing these charges, because they're bringing them just for political reasons, is basically dishonest. And like I said, he didn't just say this in private. He went out in public, and he amplified it by repeating it several times. And so I would like to just play an excerpt of one of Judge Bailey's false accusations against the commission. And this was from a radio show. It's the entire interview is in evidence. The transcript is also in evidence. So I'm just going to play an excerpt because I only have 30 minutes. So I'm going to start at... The first segment is going to start at 2 hours, 6 minutes, 26 seconds, and it's going to go to 2 hours, 8 minutes, 44 seconds. And this is Exhibit 21, the audio. The transcript's Exhibit 22.
Would be remiss if we did not discuss this. It came up on the program a couple of days ago. Somebody said, hey, I heard you ran Judge Steve Bailey on it. There's this story going on now that he has been accused of misusing his position on the bench for personal profit somehow. And I have not heard anything about this. But the reason I haven't heard anything about it is mainstream news has not picked this story up at all. And when I finally found out, I think it was in the Mountain Democrat in El Dorado County, within the hometown paper, Judge Bailey, this accusation was so specious as to be laughable. And it was so obviously an accusation that was made just in an attempt to discredit you. And it really had to do with your execution of a judicial practice that I'm sure most progressives would have approved wholeheartedly of. And that was trying to not incarcerate as many people as you could not incarcerate.
You know, it's actually two different pieces. Ultimately, what the real charge is coming from a group, this Commission on Judicial Performance. It's a commission that is almost wholly, except for a couple members who are appointed by the Chief Justice. Every last member of that is appointed by Jerry Brown. In fact, some of them were delegates to the Democrat National Convention, are on many of them are on the...
So it's like almost every other state board and commission. It is so far left they can't see the right from where they are.
That's exactly it. And what their biggest problem is that I'm running for Attorney General.
Of course.
I'm running against the hand-picked appointee of Jerry Brown. They don't want me to do that. So what they've said I can't do is I can't use my title. They didn't give me the title. The people of the state of California elected me to the title. The title is Judge. I was a Superior Court judge until I retired. I retired in August of 2017. What's very interesting about these charges is that they're brought 2 days before the filing period to run for Attorney General.
And then the next excerpt is going to be from 2 hours, 10 minutes, and 5 seconds to 2 hours, 11 minutes, and 52 seconds. And again, that is Exhibit 21. That's the audio, and the transcript is Exhibit 22.
And you went on the bench. CHI was the only provider, and it's the one your son worked.
And was the one my son worked for. So I went to the presiding judge, Suzanne Kingsbury, and I told her I was concerned about this. And so her advice was, well, go get an ethics opinion from the California Judges Association. And that's where judges had been told that you go to get these opinions, and if you get the opinion and then follow the opinion, then you were supposed to be okay.
And they will say, okay, this doesn't look like impropriety to us.
Right.
Either do it or maybe you shouldn't.
So I picked up the phone. I called one of the judges I knew on the ethics committee, a Judge Fall out of Yolo County, and he told me, look, the way to do So to go back to him didn't seem proper to me, so I called Judge Klessman. I gave him all the facts. He wrote an opinion. He gave it to the committee. They approved it through their normal procedure, gave it back to me, and I followed it as they had required me to follow it. 8 years later, this accusation then pops up. I mean, this is the time.
You think it's political?
Gee, I wonder. I'm shocked.
Yeah, I almost laughed when I saw the story. I thought, come on, really? Did anybody going to buy this?
So that was his initial defense theory to sort of explain his predicament. He continued with that in a few of his submissions in this case. And then he eventually started to abandon it, and he adopted a new theory. And that new theory was that Judge Kingsbury was the cause of his problems. According to Judge Bailey, Judge Kingsbury felt threatened by him, that he inquired about how long she had been presiding judge out in El Dorado Superior Court, and because she felt threatened and wanted to cling to this presiding judge title, she decided to essentially scatter her minions throughout the courthouse to uncover things on Judge Bailey. So,
Excuse me, sir. Mr. Anthony Capozzi has a question for you.
okay.
I have a question, Mr. Lizarraga. How do you account for the charges in this case being filed 2 days before his candidacy has to be filed? Was that planned that way? How did it happen?
It was just filed. As you know, the investigation was a prolonged investigation, and the charges get filed when the notice gets approved, and there's no nefarious conduct. I mean, I realize he's trying to draw an inference from that, but...
But it's filed 2 days before his candidacy, declaration of candidacy. There's no intent knowing that that was going to happen 2 days later?
No, Your Honor. I mean, that accusation, to me, is equivalent to saying the charges lack merit. And clearly the charges do not lack merit because the special masters sustained 10 of 11 counts.
Can we consider the fact that he retired in, was it August 31st, 2017? And he doesn't file his candidacy until, what, February 26th, 18? Are you saying there's misconduct during that period of time after he retired?
No. We are alleging misconduct through the time he's on the bench. I mean, we are... Go ahead, I'm sorry.
Okay. The other question I have is he says his new theory is blaming Kingsbury.
Correct.
In the master's report, they're pretty clear there was a animosity between the two.
Well, they indicate that there was a toxic environment, but the toxic environment is not a mitigating factor. I mean, you think about it, did the toxic environment cause any of the conduct here? I mean, did it cause him to make stereotyping remarks, or did it cause him to accept gifts he wasn't supposed to accept, or did it cause him to use his title and to campaign throughout the state for a partisan office?
Are you disagreeing with the master's findings on the first 6 counts?
Yes, with some of the findings, we're asking for additional factual findings. For example, they in count 2, count 2B, and count 2C, they made no findings.
Yeah, right.
So, I mean, do you want me to list
Not the others, but the other ones they're saying was misconduct, not conduct prejudicial.
There's various objections, and most of those go to the level of misconduct that the masters found. They found a number of improper action,
right,
and we believe that those actually rise to the level of prejudicial misconduct.
Okay, thank you. All right.
So what those two theories demonstrate is that Judge Bailey essentially has no self-awareness. He does not recognize his misconduct in this case. And it's not just limited to those theories. And I don't have, the time to go through every single one of the counts, but you'll notice that in Judge Bailey's responses to the commission, he's saying he disagrees. He says, no, that's not correct. I appreciate my my misdeeds. I understand what I did wrong. But if you really closely examine his writings, he really does not have any appreciation for the impropriety of his acts. And I'm just going to list a couple of those. For example, in count 6, if you'll recall, count 6 was the Gay Taylor remark. So the masters found that he made a remark, stereotyping remarks about gay men. And they didn't give a lot of detail, but they made that particular conclusion. Now, this particular exhibit is in evidence. It's Exhibit 236, and it's an email that was drafted by Susan Thurman, who is one of the individuals who heard the Gay Taylor remark, and she drafted it when the facts were fresh in her mind, the same day she heard the comment. And so this is what she says, and I'm just reading an excerpt of it, but you can take a look at it again. It's Exhibit 236. She's saying this is what Judge Bailey said. I got it in, he's referring to his clothes. Somebody made a comment, oh, you looked very well put together today, or your clothes look a little bit odd. And then this is his response. I got it in Paris or somewhere from a gay guy, so I know it is a nice shirt, as the gays only have nice clothes. And I know it goes together with what I'm wearing because he picked it out, the whole thing, and gays really know how to dress. So that's his remark. Again, the masters made a finding. Judge Bailey is saying, I fully appreciate, I fully am aware of my misconduct, but take a look, like I said, take a look at his submissions prior to this hearing, and if you look at his proposed findings of facts to the masters, so what happens is there is a hearing, and after the hearing, both sides propose what they think the findings of fact should be and the conclusions of law. This is Judge Bailey's proposed findings of fact and conclusions of law. This is page 6, this is count 6, page 81. And I'm just reading the excerpt. So if you want to take a look at it again, Bailey's proposed findings of facts, page 81. The statement was not about all gay men, and there's a typo here. There no factual basis to claim that Judge Bailey made any stereotype statement. Judge Bailey does not admit to making a remark that perpetuates stereotypes. Well, you just heard me read that exhibit. Clearly, it's stereotyping remarks. Clearly, it's about gay men. But even as of his proposed findings of fact, he's saying it didn't happen, I didn't do it.
5 minutes.
5 minutes? Wow.
Yes, there's a question from Mr. Richard Simpson.
I guess what I'm trying to understand is what weight are you suggesting we ought to be giving to Mr. Bailey's assertion that this is a sort of a political political exercise, for example? I'm not sure what you're saying, suggesting how we ought to consider that. Are you suggesting, like, for example, in the master's findings, they didn't find willful misconduct on any of the counts. And so are you suggesting that we ought to impose a higher level of discipline than we might otherwise without findings of willful misconduct because he asserts that this is a political exercise? I mean, is that, I guess I'm trying to understand why you're sharing and giving that such weight in your argument.
Okay. First, you don't need a finding of willful misconduct to censure or remove a judge under the Constitution. Excuse me. And obviously we're not asking for his removal because he's retired.
Correct.
As I indicated, there are certain factors in commission case law that the commission has stated we look at when we want to make a determination, what's an appropriate sanction? So one of those factors is whether the judge demonstrates an acceptance of responsibility, whether he admits the misconduct or shows that he understands what he did wrong. And so that is one factor for you to consider. And so I played that, and obviously I'm not going to have time to go through all his other denials in here. It's all in the paper. But that is a demonstration that he is unwilling to acknowledge the impropriety of his acts. It's not his fault. He's always looking for a scapegoat. It's either the commission, it's Judge Kingsbury, or it's just, like I said, I'm obviously not going to have time to go through it, but he just continuously denies that he committed all these different allegations, which the masters have already sustained 10 out of 11. And am I at the 10 minutes?
You have 2 minutes.
2 minutes. I'm going to have to rely on the briefing. Another factor for you to consider is the extent of this misconduct. I've already indicated the masters sustained 10 out of 11 charges. Several of the counts had multiple subparts. For example, count 9 had 25 subparts. And we are asking that you make findings as to each one of those, just like you did in Judge Creep. For example, Judge Creep, like here, had 11 charges. 8 were sustained, yet the commission, in its decision and order, found that he committed 29 acts of misconduct. How did you get to 29 out of 8 charges? Because there were multiple subparts, just like here. Now, we could have a notice with 60 charges, but for organizational purposes, we just group similar conduct under one count. That doesn't mean he gets the benefit and say, well, it's all under one count, therefore it should just be one act of misconduct. So also these multiple acts that he committed were over an 8-year period. This, unlike Judge Creep, where some of the commission members, if you recall, had questions for me that, this was just conduct, it was pre-bench conduct, it was in his first year. Basically, what has he done lately? Well, here you have a broad sort of picture of who Judge Bailey is on the bench. You have 8.5 years. Every year he was engaged in some kind of misconduct. And unlike Judge Creep, who kind of started out high and then his misconduct graph kind of started trailing off, not a whole lot, but a little bit, it started trailing off. Judge Bailey's misconduct graph is the opposite. He's consistent, and then towards the end of his tenure on the bench, it ramps up. He's engaged in his most serious misconduct, the most egregious misconduct at the end of his tenure, when you would think he'd be getting it. He'd be learning and he would be improving his conduct, but he absolutely was not.
Mr. Lizarraga, it's time.
Thank you.
Judge Bailey will make the additional presentation, and I would request 10 minutes.
Okay.
Thank you for the opportunity to be here today to speak to this august body. I have been specifically asked to deal with the issue of the political nature of the proceedings, and I want to do that. The political nature is really multiple-fold. Back as far back as 2012, the record is clear that there was significant hostility on our bench. Judges were being challenged in contested elections. The presiding judge and myself were on opposite sides of those elections. They were quite expensive for El Dorado County standards, running almost $500,000 apiece. And not just expensive, but they were nasty and bitter. And the initial sets of charges to the commission began after those elections. In 2014, there were significant, mean, nasty elections, the presiding judge on one side, myself on the other. In 2016, there was a challenge against another sitting judge in the county. I opposed that sitting judge, and the presiding judge supported him. The record is absolutely clear that Suzanne Kingsbury used her position and the staff and resources of the court to exact political retribution in that case. But I think the real issue of politics is there's no mystery. I ran for California Attorney General in 2018. I was one of 2 voter-nominated candidates for Attorney General. I happen to be a Republican. There happened to be a Democrat whose our preferences were to individual parties. But we're not nominated by our political parties that we may be registered with. We are nominated by the voters of California. And prior to ever getting into that process, I reviewed the Constitution of the state of California. I looked at the case law that had been decided both on the state and the federal level. I looked at California's process for running for non-judicial and judicial office. I reviewed the Chief Justice's video on judicial fundraising. I came to the conclusion that the proper process for running for non-judicial office, looking at specifically at Article 6, Section 17, that makes it permissive at or before the time that a declaration of candidacy, a very specific document is filed, a judge may request. And it's a permissive statute because the judge doesn't have to request that. But it gives you certain additional rights in terms of communicating with voters that you wouldn't have if you remained an active sitting judge and were running for a non-judicial office. The reason I bring these up is not to say that the decisions you're going to make today are whether you're going to say Judge Bailey did this or Judge Bailey did that. But the decisions on the First Amendment decisions that you're dealing with in this particular case, and I think it is a case of first impression, because the best I can tell, I'm the first sitting judge in the history of California, at least in the last probably 70 years. I didn't go back further than 1950. But we've never had a judge that actually files and runs for state office, statewide constitutional office. Before I made the final decision that I ought to do it, I did talk to people, just as the record reflects. I talked to people in Los Angeles County and in San Diego and in Orange. There was no mystery about the discussions that took place. Most of the discussions were in a private nature, going to somebody's office on my free time and sitting down and talking to them to determine in advance whether there'd be a possibility of running for the office and a probability that I could get elected to that office. But having looked at the process, I realized that you can't do any of this, first, without having a certain amount of support, and secondly, without being in a position to raise money. And as the Chief Justice says in her video, judges are not prohibited from raising money. So judges are, however, mandated to follow the law. And the law in California requires that prior to being able to raise money, you need to form a committee. You need either on the judicial side or on the non-judicial side, you've got to follow the same requirements. You need to get a treasurer. You need to file a statement of intention. That doesn't make you a candidate. That simply authorizes you under the Fair Political Practices Act and California's Elections Code to go out and be able to file.
Your Honor, Judge Erica, you has a question.
Sure.
I'm sorry to interrupt, and I'm taking us back to what you had talked about earlier because I did not want to interrupt.
I understand there are, difficult relationships sometimes among colleagues and in a court setting or anywhere. And so to what extent do you think someone else's conduct excuses our own bad conduct or our own conduct? Because I'm trying to fit in what you're saying about Judge Kingsbury and, what the record may show.
I'm not suggesting that it excuses an individual's conduct. I'm trying to describe the nature and the relationship and what was happening on the El Dorado County bench at the time. And that's it. Thank you. Any other?
I have it. Go ahead.
Mr. Capozzi?
Yes.
Why didn't you ask for another ethical opinion on whether or not you could raise money? You asked for an ethics opinion on one of the counts here while you were sitting on the bench.
Sure.
Why didn't you ask for another ethics opinion?
Because it appeared clear in California statute that there was a process that you went through to be able to actually raise money. When the Chief Justice says on her video that judges are permitted to raise money, that seemed, and the law simply didn't prohibit it, just required that you follow a certain set of steps within California statute. When you read the canons, Canon 5 doesn't have a prohibition against raising money by a sitting judge. So you have to, if you look at the canons and there's no prohibition, then what would you normally rely on but the state of the law? Now, that's not to say that I didn't also consult with attorneys that were versed in public campaign law. I did, and in fact, ultimately hired the firm of Bell, McAndrews, and Hilltack that does campaign finance law. I mean, that's their practice.
Thank you.
Judge Bailey, could
Yes.
I interject a question here?
Yes.
Justice William Dado has a question.
Do I understand then that you would disagree with Judge Rothman's treatise with regard to the extent of activity a sitting judge can engage in prior or while still on the bench? Judge Rothman, as I think you know, talks about private planning activity as being something that can be done as long as it's done away from the courthouse. You seem to be articulating a different position. Am I correct?
I don't really, no, I don't think I am articulating a different position. I didn't campaign out of the courthouse. I took time off. When I went to Southern California to talk to people, I was on my vacation time, or I was on a weekend. I literally went as far away from my own courthouse as possible to ensure that I wouldn't have people who would come in front of me. El Dorado County, South Lake Tahoe, El Dorado County doesn't get a lot of contact from people in Orange County or San Diego or Riverside.
Okay. But am I correct that you were raising money?
Absolutely, that's a public record.
Okay, and you believe that soliciting contributions and raising money falls within the private planning?
I think it falls within the ambience of California's statutory scheme for campaigns.
Okay, and you don't see any ethical issues that raises?
No, not unless, I don't see an ethical issue directly unless it's someone who would have a reason to come before the court, particularly when the statutory scheme that applies to sitting judges says that you can go raise money.
And you realize that at least people on your behalf were indicating that you, naming you with your title, indicating you were a candidate for Attorney General for 2018. And you don't view that as going beyond private planning activity?
I don't, because it's a third-party activity, and they have a political, First Amendment political right to do that. And respectfully, I understand that there can be some disagreement, but the fact of the matter is I think the statute is controlling, and the statute lays out a statutory scheme that we in California have adopted. The California legislature has adopted, and they didn't put restrictions in the law that single judges out.
But now it's correct, am I correct? My understanding of the record is that with respect to your campaign committee and other people who were working on your behalf, you didn't take any steps to tell them not to use your title.
I did not.
I have a question.
Yes.
Isn't it true, in November 2016, you sought the advice of former Judge Julie Conger, who is an expert on judicial ethics, and she had advised you that you should not distribute flyers that included a photograph of you in your robe, and she urged you to remove your judicial title from emails related to your campaign to avoid using the title in campaign literature until after you took leave. Is that correct?
No. What I asked her was whether I could have whether a flyer with me in my judicial robe was proper. She told me no, and we didn't distribute it. We destroyed that.
But she also advised you that you should take leave from the bench. Is that correct?
No.
And you didn't do that. This is November 2016. You filed your intention in April of 2017, correct?
We filed a notice of intention in April of 2017.
There's a question from Mr. Richard Simpson.
Maybe to make sure I understand, the context of the comments that you've been making are that the campaign-related activities prior to your resigning from the bench, in your view, aren't or shouldn't be considered misconduct in the first place.
That's correct.
Basically?
I think that's correct.
Okay. I just want to make sure I got the sort of the bottom line.
Sure.
Okay. I understand. Thank you.
And I think that's an important point. And I understand the how distant I am from where the examiner is.
And the masters.
The reason, and even the masters. But the reason that's very important is, it isn't reasonable to expect that you can go to the date that the Constitution requires or gives you permission to take a leave of absence and assume that on that particular day, all of a sudden you take a leave of absence and begin to run for public office. Now, you can look back and say, oh, Judge Bailey should have, that should have just jumped right out at him. I suggest to you that a decision that you make is going to impact every judge forward that may wish to run for, say, district attorney, a Bonnie DeMoss, for example, or a Rackauckus or a Zellerbach, or any of the other people who have been sitting judges at the time that they've run. It's not realistic to assume that they waited until the day they could file without talking to anyone, without going out and trying to find out whether they would have support. I didn't do that either. I looked to people, I talked to people, I suggested to people that I was thinking and or others suggested I was going to run. I admit that. But I think it's permitted under California's statutory scheme. And I don't think it's prohibited under the way the canons are written.
Thank you.
Judge Michael Harper has a question.
Sure.
Judge Bailey, I was curious on the Attorney Clark issue.
Sure.
You were clearly friends with Mr. Clark and officiated his wedding, went golfing. When you appointed him as a special master, why did you feel like you didn't need to disclose that relationship?
Because it was an informal relationship. I was the bar president for roughly 2 years,
I'm
certainly.
sorry, it was an informal relationship. You mean your friendship with him or the appointment?
No, I knew him. I knew all the attorneys in El Dorado County.
But
It's a
don't judges
small
have an
county.
ethical obligation to disclose that when you're appointing an attorney onto a case? I think it's $350 an hour on a matter. Why did you feel you didn't need to disclose that? I understand if you felt you didn't need to declare a disqualification for yourself, but don't you think you still have an obligation to disclose that friendship?
I don't know. At this point, that probably would have been the safe way of doing it. But at the time, because I knew every lawyer, having dealt with all those lawyers, I was in South Lake Tahoe. What I was looking for in the Clark matter, because of the nature of the litigation and how the attorneys were, one, taking up significant court time over issues that were difficult to ferret out what the actual dispute was. That's why we appointed Clark. Now, he was on a list of discovery referees, as was Dave Kimbellick, a number of other lawyers from the Placerville area. We had some lawyers out of South Lake Tahoe who were also on our discovery referee list. But in my opinion, the lawyers in South Lake Tahoe had become corrupted because there was too much discussion over this particular issue in South Lake Tahoe. So it was advisable to go find a lawyer outside of Tahoe. Clark was one. Obviously, I knew who he was. I knew Dave Kimbellick. I knew the other lawyers that were on the list in Placerville. We had practiced together. We knew each other. But just knowing them didn't, to me, rise to that level of that particular individual, being at a point where I thought it was, the relationship was too close and would require disclosure. At that time.
2 minutes, Your Honor.
Thank you.
I'm done because
I have
you
a question for you. In your opening remarks, you characterized this as political in nature, and that this is in retaliation, and you named the judges who you thought were out to get you. But you also referred to the purported political makeup of this commission, although you characterized it as this august body. Are you suggesting that the commission is out to retaliate against you for political reasons?
I'm not suggesting that, but in the height of a political campaign, when the commission staff, when you guys get to take the heat, I guess, for actions of the commission staff, 2 days before filing, they file an accusation based on conduct that was, at that point, over 6 months old, if it even was occurring. There was almost no action other than letters from the commission staff up until I announced I was going to retire, and then all of a sudden it went into hyperspeed, and I retired at the end of August. Immediately announced that I was going to run for Attorney General in early September. And then roughly, not quite 6 months, but almost 6 months later, they filed the accusation. Again, 2 days before I'm going to file. How do you perceive it? Do you think it sounds political?
I'm asking you the question.
Yeah, I think it sounds very political.
At your time. Ms. Patel-Kasparian has a quick question.
From the 11 counts of alleged misconduct, which one are you the most surprised with? And if varied, which one of the positions most disappoints you?
Frankly, I don't know that I'm surprised or disappointed with any of the counts that were brought. The facts are what the facts are. What I'm most concerned about, I will tell you, is any findings that you ultimately decide to make on the issue of judges running for non-judicial office. I think it really needs to be considered. Frankly, I would encourage you to be absolutely narrow in any finding that you make, because if you're not narrow, you will impact any other judge, good, bad, indifferent, people you support, don't think ought to run in the first place. But there is it's a Mack truck waiting to go through that opening. And I think, from my perspective, I looked at our United States Supreme Court decisions, as I mentioned. I also looked at the California case law, and I looked at the California statutory scheme, compared it to the canons, and I believe that I was on solid legal ground when I made the decision to run for California Attorney General, and in the manner that I did run for California Attorney General.
Thank you, Your Honor. Mr. Murphy, you can relinquish some time for further questions to Mr. Bailey, or you have, let me double check. You have 8 minutes.
There are a few points I would like to make, Madam Chair.
Okay.
First of all, I listened to Mr. Lizarraga, and I'm sure he's not trying to mislead the commission, but when he played this transcript of Phil Cowan, interview of Judge Bailey, and he gave a broad brush approach, and this is how Judge Bailey viewed the commission. Well, the question was relating to CHI and how he perceived CHI and the allegations of the commission that he was personally profiting by the referrals of the Scram devices to CHI. That's what this transcript's about. Mr. Cowan says misusing his position on the bench for personal profit, and then Judge Bailey talks about CHI and how he obtained an ethics opinion before he even referred any matters to CHI. So we're not talking about this theory that somehow everything the commission has done was politically motivated, which raises the next issue, and that is what Madam Chair said about the perception. Well, if you look at CCP section 170.1, when a judge is disqualified, if an objective person knowing the facts would conclude the judge could be fair and not fair and impartial, it's a perception issue. It's an optic issue, as my millennial children say. And that's the problem here. It is a perception issue. And he's being criticized for raising that issue. And the other point I wanted to make is that in connection with these activities in campaigning for political office, and look, that was never hidden from anyone. Judge Bailey was exploring a campaign for Attorney General and engaged in campaign activities, as the special masters found back in 2017. But the question here is not whether he was campaigning or engaging in an exploratory campaign. The question under Canon 5 is personally soliciting funds for a political organization or non-judicial candidate, or making speeches for a non-judicial candidate. What's a candidate? It's not defined in the canons. Candidate for judicial office is, but a candidate is not. And what Judge Bailey did before he decided to run for Attorney General was look at the Constitution, research the law, look at the canons, review the elections code, and he correctly determined that a person becomes a candidate when they file the Declaration of Candidacy, which he did in 2018 after he had retired from the bench. And I submit this canon is at best ambiguous, but if we read it literally, he was not a candidate for non-judicial office until 2018. A couple of additional points. Mr. Lizarraga.
Could I interrupt with a question on that, Mr.
Certainly.
Murphy? And this goes to the question that I asked Judge Bailey. He said he did not disagree with Judge Rothman with regard to that dividing line between what you can do before you leave the bench and what you can do after in terms of being a candidate for non-judicial office. Yet you seem to be saying that as long as you are not an officially declared candidate, there are no limitations on your conduct. Do I understand you correctly or not?
Well, that's not quite as broad as I would have put it. I did it in connection with Canon 5, and Canon 5 does have a bright line standard, candidate for non-judicial office. I think what Rothman is talking about, and I would share in his view, that there are activities that a judge could engage in that would violate perhaps other canons, but not Canon 5. And I think in a campaign or an exploratory campaign, in performing the obligations required under the Elections Code or the Fair Political Practices Act in establishing a campaign committee if you're going to solicit money, I don't think those are the types of activities that are directly addressed by Canon 5. And certainly, he did not violate Canon 2 in the exploratory campaign or in the campaign. The question is, was he a candidate? Because that's what Canon 5 addresses, a candidate for non-judicial office. And he
Again, you define that by reference to filing a candidacy statement. Am I correct?
Under the Elections Code, that's when you become a candidate.
Okay, so under that view, you can refer to yourself as a candidate. Other people who are working with you can refer to yourself as a candidate. You can solicit donations. None of that makes you a candidate. It's only the filing of the statement. Is that what you're saying?
That's what I'm saying.
Okay.
Okay.
Mr. Murphy, 3 minutes.
Thank you. 2 points, quick points. Mr. Lizarraga said that there is this new theory involving Judge Kingsbury. Well, I've been representing Judge Bailey from day one. And the first theory that we defended the case on was that Judge Kingsbury and Judge Bailey were at odds with one another. There weren't any issues with respect to political campaigning when the initial preliminary investigation issued in this case. So that's not a new theory. That's a theory we had from the very beginning. It's when Judge Bailey decided to engage in an exploratory campaign and campaign for Attorney General that the First Amendment and the political issues arose. The thing that's most noticeable about Judge Bailey's activities and what the special masters found is that none of the conduct that they found was a violation of the rules or the canons involved conduct in the courthouse or his performance of job duties as a judge. He didn't abuse his judicial power. There was no question about his fairness and impartiality as a judge. There was no questions regarding his honesty in discharging his judicial duties, and there's no issue of contempt abuse or anything else. If you look at the decisions of the commission on censure, all of those involve willful misconduct or abuse in the courthouse, and we have an absence here. And I submit that if discipline is imposed, it shouldn't be a censure, but a public admonishment. Thank you.
Mr. Lizarraga.
I'm going to have to bounce around, so forgive me. These are Exhibits 78 and Exhibit 79. You know, and I'll try to do this as quickly as possible, but Mr. Murphy said that, you know, blaming Judge Kingsbury has not been a new theory. He's been representing Mr. Judge Bailey for X number of years. Well, just look at the submissions. Look at his answer. Look at his responses to the commission. Look at his briefs to the special masters, and then look at his briefing after the hearing. Clearly, this is a new theory. Judge Bailey says that he made the decision that he became a candidate by looking at the Constitution, Article 6. We've explained this, you know, in the briefs. Nothing in Article 6 defines candidate. It talks about when somebody becomes eligible for election. Mr. Murphy just said that Judge Bailey did not become a candidate until 2018. Well, if you look at counts 7, 9, 10, and 11, between August of 2016 and August of 2017, Judge Bailey was going up and down the state telling everyone he was a candidate, and he hadn't filed his declaration of candidacy yet until 2018. And as you can see by these exhibits, he's using his title, he's saying he's a candidate, and he's asking for money for his attorney general candidate. There's no conditional language there. He's not saying, I'm thinking about becoming a candidate, I'm potentially a candidate, this is an exploratory campaign. He's declaring himself a candidate 15, 16 months before he ever files his declaration of candidacy. He says this is an issue of first impression. I'm not really sure what he means by that. There's a Zellerbach case that is right on point. And what I find interesting in Judge Bailey's opening brief and reply brief to this commission, he never mentions Zellerbach, just completely ignores the case. The case is right on point with regards to Canon 2B2, using of your title for your personal interest. And it clearly states that a judge, when a sitting judge comes back on the bench, the judge cannot use his or her title to benefit. You remember the facts of the case. Judge Zellerbach was on leave of absence. He comes back. He uses his title to retire a non-judicial office campaign debt. The commission was very clear, you can't do that. So when he comes before you and says this is an issue of first impression, clearly he did not read the Zellerbach case that came out in 2010, 6 years before he embarked on this exploratory actual campaign. He says he spoke to people. Well, he spoke to Judge Conger, and she clearly told him not to engage in the conduct he eventually engaged in. He testified. I know what his lawyers are saying now, and they're making these legal arguments, but look at his testimony under oath. He testified over 2 days. He's not saying the things he just said before you now. You can look at his testimony. Like I said, look at page 956. And what he's telling you in 956 is the, quote, research he did is he read Judge Rothman's handbook extensively. That's his words. And he says, and I'll try to read this quickly, but I gave you the page so you can take a look at it. And so I reviewed that, and of course, it compares it to the canons. And so I compared it to the canons, looked at activities that I would be involved in, concluded that, in my estimation, after looking at it, that the types of things, talking to people and letting them know that I might be interested in running, and I'm interested in their opinions, and whether they would be willing to support me, and those types of things were permitted. So based on his reading of Rothman, this is his testimony under oath at the trial, based on his reading of Rothman, based on him examining the canons, he believed he could engage in this conduct. What's interesting is he's very vague about Rothman. He doesn't say what he read. He doesn't say what section he read it in. He doesn't say what page he was on. And if you look at Rothman, clearly there's nothing in Rothman that says that a sitting judge, can use his or her title to promote their political campaign for a partisan office. There's nothing remotely like that. So, you know, when he comes in here and tells you he did all this research, take a look at his testimony under oath. I think what he's saying now before you should be viewed with a high amount of skepticism. He said, I already sort of touched on this, he said that he was just talking to people. Look at these exhibits, and there are too many to list. But you have all of them. He's not just talking to people. He is clearly, as you can see in these exhibits, he's requesting their monetary donations in his name for his campaign. He says that he spoke, or he said that I believe it was, that he listened to a video that the Chief Justice talked about lawyers can raise money. I think he was being kind of vague about that. He's not exactly saying what he listened to, but I'm quite sure if the Chief Justice was talking about raising money in a judicial campaign and not for a non-judicial partisan office. He says that there's nothing in the canons that say you cannot raise money for a non-judicial office. Take a look at Canon 5A3. It's what he was charged with, what the masters found. It clearly has a personal solicitation prohibition in there, which is similar to many other jurisdictions, and it says that a judge or a candidate cannot personally solicit contributions for a non-judicial candidate, which is what he was. He indicated that he never did any of this on the premises of the courthouse. He was never charged with necessarily doing the campaigning on the courthouse, but so it's clear, he is actively campaigning throughout California while he is a sitting judge in El Dorado County. It doesn't matter if it was on his day off or that he, took a sick day or an annual leave. He is campaigning while he is a sitting judge, and that's significant. Finally, and this is one of the factors that you are supposed to look at in determining an appropriate sanction under Policy Declaration 7.1, whether the conduct was done knowingly and intentionally. And clearly there is evidence here that Judge Bailey engaged in this conduct intentionally. Again, he spoke with Judge Conger. Judge Conger put him on notice that he was not supposed to do the various things that he did. Yet he completely rejected her advice and went ahead, used his title and campaigned. In his arguments to this commission, he says that he reviewed the canons and understood what they prohibited, but thought they were unconstitutional as applied to him. Clearly what he's telling you is, I knew what the canon restricted, but I thought it was unfair or unconstitutional, so I went ahead and did it anyways. So take a look at Judge Conger's testimony and his own language. He is clearly acting knowingly and intentionally when he's using his title and he's campaigning.
Mr. Richard Simpson has a question.
Are you suggesting that we should make a finding that some of these campaign-related activities were willful misconduct as opposed to prejudicial misconduct?
No, I'm not. I agree with the special master's findings that this conduct rose to the level of prejudicial misconduct. The only thing that I objected to is, I didn't object to, I asked for an additional finding by the commission because for organizational purposes, we put the campaigning under count 9, one count, but there are 25 subparts to that, and we are asking you to make prejudicial misconduct findings as to each of those subcounts. Because for the most part, they're on different days, they're different locations, they're different activities that he's involved in, that he's violating the canons. He's asking, for the benefit, because it's under one count, he should just get one act of misconduct. You didn't do that in CREEP. There's no reason to do it here. Okay, so if there are no further questions, I will submit it. Thank you.
The matter is taken under submission.